Good afternoon, everyone. My name is David Arcilla with the Better Business Bureau of Southeast Florida and the Caribbean. For those of you that have attended my webinars, you know who I am. For those that are not, firstly, welcome during this tough time. I know a lot of you are either working from home or finding ways to obviously make certain things happen, but we wanted to take this time to provide some information to you that we think would be very helpful. Today in this webinar, we have Kristen Cavallo. She is actually our human resource advisor from our PEO CoAdvantage. And we also have Ms. Tania Bartolini. She is of the law office of Tania Bartolini. She is actually one of the board of directors of the Southeast Florida and Caribbean BBB. So before we get started, just a couple things. Number one, this webinar will be recorded. So for any of you that would like to review it, once it's done, we'll get that recording out to you guys. And secondly, we will be answering questions at the end of the webinar. All of you should have a chat box, if you would like to drop those questions in there, and at the end of the presentation, we will be sure to answer those for you. So without further ado, I am going to let Kristen and Tania take the floor. So please, ladies, go ahead.
Thank
you, David. Good afternoon, this is Kristen. We're going to be going over today the FFCRA, what employers need to know. So just as a reminder, this is a legal disclaimer. This is intended to provide general best practices employment guidance. CoAdvantage, myself, Kristen, we do not render legal advice, so this document was not prepared by an attorney. This was prepared based on best HR practice.
Okay, and then a legal disclaimer, since I am an attorney, this is Tania Bartolini. Everybody please understand that this presentation does not create an attorney-client relationship. It is not confidential. As David stated, it is being recorded and will be shared. And this is not to be construed as legal advice. If you have legal questions, you should talk to an attorney regarding your own issues, and all on a case-by-case basis. Next slide, please.
Okay. So we're going to be going through the FFCRA. Probably everybody knows, we've heard it all over the news. It's the Families First Coronavirus Response Act. There's many different facets to the act. What we're going to focus on today in this presentation is the Emergency Family and Medical Leave Expansion Act, the Emergency Paid Sick Leave Act, and also the tax credits for the paid sick and the paid family and medical leave. Big reminder, this was effective on April 1st of 2020. So for the agenda during the presentation, we're going to be going over who's the covered employers and the eligible employees within those covered employers, reasons for the different leaves, how to apply and calculate the paid leave, and also as employers, what you need to do about giving notice to employees, documentation, and record keeping. So this act applies to all private employers and nonprofits with less than 500 employees, and also public employers where there is no employee limit. So covered employers, the employee count you have to use are all full-time and part-time employees. This is going to include anybody who is possibly on leave, any day laborers that you might have, temp employees that you have, and any sort of employees with a joint or integrated status. Employees who are not covered would be any foreign employees, meaning they're not on payroll within the United States, they're on a foreign country. Independent contractors are employees who are paid by a 1099, and then employees who have been laid off, meaning terminated, or furloughed. So with covered employers, there is a small employer exemption. This is because this act could put financial strain on an employer of less than 50 if it applies. So you just want to look at if you possibly fall under that. You have to be a small employer with 50 or fewer employees. The leave request must be due to the need for care for a child or a child care place that has been closed. So this small employer exemption does not apply to anybody who has COVID, is experiencing symptoms of COVID, or is caring for somebody with COVID. This is only for somebody who has to care for a child with the emergency paid sick leave, with the expanded FMLA, or somebody who has been out of school or the place of care for a child has closed.
Now, wait, sorry, go back, please. Just from a legal perspective, it does say that you can deny leave to an otherwise eligible employee if their absence would cause expenses to exceed available revenue, pose a substantial risk, or prevent operation at a minimum capacity. Now, I want everybody to understand that there's no real legal guidance on what is a substantial risk, and that has to be determined on a case-by-case basis until there's case law and until the courts have formed those guidelines. So if you're in doubt as to whether or not you have to give the leave, talk to your employee, see if there's anything that you can work out with them, and then talk to an attorney if all else fails to determine whether or not that situation does pose a substantial risk to your company and whether or not you have the right to deny that employee the leave. Next slide.
So for the eligible employee, the EPSLA, emergency paid sick leave, that applies to all employees, no matter when they were hired, no matter if they're full-time or part-time. For the EFMLEA, that's the expanded FMLA, that applies for anybody who has been employed for at least 30 days. So just remember to keep in mind that the EFMLEA would apply to anybody who's doing childcare over 2 weeks. So, reasons for the leave. There are several reasons defined by this act. We're going to go over them now. Please keep in mind that these reasons only apply when an employee is unable to work or telework. So the first one's going to be the employee is under a government quarantine or isolation order related to COVID. Second one, and we're going to go into these in detail over the next couple of slides. Second one, the employee was advised by a healthcare provider to self-quarantine due to COVID-19 concerns. Third, the employee is experiencing symptoms of COVID and seeking medical diagnosis. The fourth is the employee is caring for an individual who is subject to paragraph 1 and 2, meaning they're caring for somebody who is quarantined by the government or has an isolation order, or they're caring for somebody who has COVID concerns. Next slide. Thank you. The fifth reason is the employee is caring for a son or daughter if the child's school or childcare is unavailable or closed due to COVID-19 precautions. So that one is different. We're going to go over that in a minute. Sixth one, the employee is experiencing any other substantially similar condition specified by the Department of Health and Human Services. There isn't any guidance on number 6. So I do want to let you know that you should err on the side of caution. Anytime there is a pandemic, and if somebody does not have COVID, but is seeking guidance, help with the CDC or the HHS, you do want to ask them if, there would be concerns regarding this for somebody to keep working in person or telework to qualify for the reason for the leave. So big thing, unable to work or telework. If somebody is able to work or is able to telework, they're not going to qualify for the emergency paid leave or the expanded FMLA. So to take the leave, you have to be unable to work physically in the brick and mortar place, or you have to be unable to work to telework. So examples of people who have no work available that would not qualify under this would be any employee that's furloughed, an employee who's laid off, an employee who's already on a leave of absence unrelated to COVID, if the business had to shut down temporarily or had to have a stay order, which a lot of states have stay orders, or they're seasonal workers who would normally not work at this time.
Now, also be cognizant that if you as an employer do not have enough work, okay, you can reduce the hours for those employees, and that does not qualify them for paid leave under this act. Even if the reason why you had to reduce the hours and the reason why you don't have enough work is COVID related, it still does not matter. This whole thing is because if you have the work and they're unable to work, then you have to give them the leave. But if you don't have the work, then you can reduce their hours and you don't have to give the leave based on that fact alone.
So to go into unable to work or telework is at the employer's discretion. There was a lot of talk before forcing people to work at home because of stay orders. That if it's a possibility for the employer, of course, from an HR standpoint, we always want employees to be productive and working. And if it's possible to have people working from home, that is the best option. But it is at the employer's discretion. So if an employee does not have the job capability to work from home or the technology from the employer, then this is not something that is forced. It's at the employer's discretion. Telework can also occur during normal hours or other type of working hours, depending on how the employee and the employer agree upon the working relationship. And then we just want to make sure that a continuous workday rule, it doesn't apply when somebody's working at home. Just because of the flexibility of working from home, we do want to keep in mind that if you do have employees working from home that are clocking in and out, we especially want to watch them to ensure that we are following FLSA, federal state law guidelines on how to pay an employee correctly.
Also, please be cognizant that although telework is at the employer's discretion, many employers are taking the Paycheck Protection Program loans or other stimulus loans, and some of those have requirements as to wages paid to be able to be forgiven. So if you are not allowing your employees to telework and you take some of those loans, you might not be able to have them forgiven like you had wanted. So just make sure that you understand, if you are going to be taking those loans and you want them to be forgiven, you might have to allow the employees to telework, and you might have to give some payments to get them able to work from home.
So we're going to go into the covered reasons more in depth. This is where a lot of employers have questions. So we just want to make sure that you understand what is covered, and then under those covered reasons, examples of things that are not covered and would not be paid. So for the number one reason, quarantine or isolation order, this is if somebody, an employee, is under a government quarantine or the isolation order. They would be qualified for the emergency paid leave or the EFMLA. No paid leave under this order would be required if the employer has work for the employee to perform. The employer permits the employee to perform the work at a different location other than where they would be working, meaning they can work from home or telework. There are no extenuating circumstances that prevent the employee from performing that work. And then another example would be a DOL gave an example of a power outage, which is unrelated to COVID, so they would not be under covered reason one if it was something that was unrelated to COVID. For covered reason number two, advise to self-quarantine. We've been getting a lot of questions on this. So easiest way I can tell you is that you may not take paid sick leave under the FFCRA if you, as an individual, unilaterally decided to self-quarantine for an illness without medical advice. So we have a lot of employees that have said, I don't feel safe, I don't want to work, or I possibly was around somebody who may have had COVID. That would be a voluntary self-quarantine that would not fall under reason number 2. So you have to make sure that if you are advised to self-quarantine, it's by a healthcare provider, which means the employee has COVID and they have to quarantine. The employee may have been around somebody who had COVID and has to quarantine, or the employee is vulnerable, which your physician or healthcare provider would let you know if you qualify for that. One of the most common reasons that I can suggest under that one would be over the age of 65. So you just want to make sure to a healthcare provider is any medical doctor, nurse practitioner, or anybody else that you're being served by with the CDC or Health and Human Services. To go on in more depth for number 2, what would not be paid under that is if the employer has work for the employee to perform, and it could be done at home, or this is a voluntary leave to where the employer has worked for the employee and the employee is refusing to come on a voluntary basis, not directed by a healthcare provider. The employer permits the employee to perform the work at a different location to self-quarantine. So if you can telework, you can self-quarantine at home, you would not be under this benefit. There are no extenuating circumstances that prevents the employee from performing the work. And then, just as an example, the employee is too sick to work. So unless it's COVID related, it would not fall under this. So reason number 3, COVID-19 symptoms and seeking diagnosis. If you have COVID-19 symptoms, you do have to seek a diagnosis. It's just urged during the pandemic. Obviously, your employer cannot force you, but you are highly encouraged with what's going on, and it is required documentation under the covered reason for number 3 that we'll go over. So you have to seek a medical diagnosis. Symptoms of COVID that somebody would have to have would include, but are not limited to, fever, dry cough, shortness of breath, and any other symptoms that the CDC has identified. The paid sick leave for number 3 must be limited to the time the employee is unable to work because they're taking affirmative action to obtain the medical diagnosis. So an example of that would be if you telework, you can take time off during the emergency paid sick to go get tested and then come back home to work. But you would not be expanding that unless you're going to get the testing.
Now,
and then, go ahead.
Sorry. Now, I was just going to say, from a practical matter, if an employee is experiencing symptoms, do not allow them to come to the office.
Yeah.
You know, and at the same point, if you're experiencing symptoms, do not go around other people, whether you think you know it's COVID-19 or not, because that will open you up to liability.
Absolutely. Let's go to the next slide. This is a continuation of the number 3 reason. So an employee would not be under the paid leave if the employer has worked for the employee to perform, if the employer permits the employee to perform the work at a different location and they're waiting for the diagnosis, as in teleworking. There are no extenuating circumstances from performing the work, or for example, the employee is too sick to work. So we're going to go on to cover reason number 4. This is care for another. The employee is caring for an individual who is either 1, subject to the quarantine or isolation order, or 2, has been advised by a healthcare provider to self-quarantine. So this individual includes an employee's immediate family member, a person who regularly resides in the employee's home, or a similar person with whom the employee has a relationship that creates an expectation that the employee would have to care for them. So you may only take this paid sick leave to care for an individual who genuinely need your care. This just can't be used just because you do have to show proof of the relationship and also that this person would generally need your care. Going on to covered reason number 5. This is for the Expanded Family Medical Leave Expansion Act. This is care for a child. So the employee is going to care for their son and or daughter if the child's school, child care place is closed or unavailable due to COVID precautions. So the DOL applies this FMLA definition of son or daughter to both the leaves, the emergency pay and the expanded FMLA. So a son or daughter is defined by the FMLA regulations as biological, adopted, foster, a stepchild, a legal ward, or a child of person, or a child of a person who is an acting local parentis who is either under the age of 18 or is 18 years old and incapable of making decisions due to mental or physical disability at the time.
Now, please keep in mind that just because you're caring for a child does not mean that you cannot work. Okay, this is also something that has to be looked at on a case-by-case basis, as a lot of people are currently working from home with children to care for, with schoolwork to teach, and they're still able to work. So this is a situation where work schedule alternatives might need to be implemented, where you would have to talk to the employer and employee would have to talk to each other, and maybe you can come up with a situation where the employee might work certain hours that are different from normal hours, or they might take some paid leave and some, some time to work. That's something that you're going to have to actually discuss with your employee on a case-by-case basis.
Okay, we can go to the next slide to go over the other part of this. You also must be the only child care provider for the child. So if you have a 2-person child care system, for example, mother, father, you do have to show that if you are the only parent putting in for this, that you're the only provider who can do it. Most of the time you will want to work with the other parent, the other job, different possibilities to see if this can be done intermittently if you are not able to work from home during that time. So the DOL, the Department of Labor, adopted the IRS guidance by limiting paid leave to only those situations where the employee must actually care for the child and no other suitable person is available. This is really important because all of this is given back to the employer through tax credits. And that means this is managed by the IRS, which means that employers have to show proof of documentation of this. That's why this is really important. We're going into all these details because if you are audited, documentation's pulled, we want to make sure that you are following the FFCRA Act to the T. We're going to go on to covered reason number 6. Now, this one did not give a lot of information with the Act. They are still working on possible guidance to go with this further. But what we have so far is the employees experiencing any other substantially similar conditions specified by the Department of Health and Human Services. Maybe they don't have COVID-19, they've been tested, but there's something else going on that they shouldn't be working. There isn't really guidance yet for this. That's why anybody who is possibly falling under covered reason number 6, you do want to make sure you're working with the employee to give them the benefit of the doubt on this one, and also with the healthcare provider for documentation. Okay, so we're going to get into the amount of hours of paid sick leave. It is divided by full-time and part-time. They are different, treated differently. So a full-time employee, somebody who's working 80 hours every 2 weeks, who is a full-time employee, normally scheduled to work at least 40 hours each work week. The employee doesn't have to have a normal work week. There are sometimes flexible work schedules, but they should be following an average of 80 hours per week. So that's where we want to look back for a 6-month period on their average hours and make sure they truly are a full-time employee when we are looking to calculate the paid sick leave. When we're looking at a part-time employee, this is a little different. Part-time employees average over a 2-week period, so you'd actually have to figure out what the average for a part-time employee is. So that would be anybody working less than 40 hours a week. Part-time employees do not have to have a set schedule. They can work, 30 hours one week, 20 hours another. That's why you are going to have to look back for a 6-month period and do an average. I'm going to go through an example of how to look at a part-time employee. Full-time employee calculation is pretty simple. When you're looking at a part-time one, the FFCRA Act actually gave this example for employers to use. So a calculation example, we're going to go through an employee. For the 6 months prior to the leave, the employee worked 520 hours. They took 30 hours of PTO. That means there was a total of 550 hours. So we're not just including working time, we're including any sort of paid time, whether it's working, paid time off, vacation, during that 6-month period. So you're going to take 550 hours and you divide it by the number of calendar days in 6 months. Then you're going to get your average hours. So you would divide that, multiply that by the average hours, and that's how you would know how much you're going to pay for the emergency paid sick leave. So if you have an employee who is part-time, you do need to do this calculation to ensure that you're not overpaying or underpaying them on the emergency paid sick leave. Okay. Payments for the leave. So the employee is under a government quarantine or order due to COVID. The employee was advised by a healthcare provider to self-quarantine due to COVID. The employee is experiencing symptoms of COVID. These are the first 3 listed reasons on the poster. These are going to be paid at 100%. So you want to make sure whatever calculation you're doing with these first 3 reasons, the employee is going to have 100% payment on this. It goes to a maximum of $511 per day. So that's where you just want to make sure you're staying within that qualified amount, because again, this is a tax credit. So this can be reviewed by the IRS. It's going to go on your 941. So this can't be an approximation. It has to be an exact amount that you're giving the employee. We're going to go on next. Go ahead.
Sorry, I was just going to say, you have to remember, as Kristen said, this is a tax credit and you have to be, you can't just, give an approximation. If you overpay, you're not going to get that tax credit. And if you underpay, you might have legal liability to that employee. So make sure your calculations are correct.
Yes. For the second part of the payments of leave, this is a little different than any other paid leave that has been rolled out. So reasons for this: the employee is caring for an individual who is subject to number 1 or number 2, meaning they're caring for somebody who has COVID or somebody who is experiencing symptoms of COVID and seeking testing. Or the employee is caring for a son or daughter due to the child's school or child care being closed. So with these reasons, the employee would be paid at 2/3 of what their pay would be. So that would be 67%. So on the previous slide, for the first 3 reasons, they're going to be paid at 100%. For this slide, the employee will be paid at 2/3 of their pay, okay? So you do want to keep that in mind. You don't want to make any mistakes getting these confused. Most payroll companies are putting in different codes that will match the tax reason and also the pay reason, but you do want to double check if you are entering anybody's payroll and they are getting paid because of the emergency sick leave or the expanded FMLA, and they're caring for an individual or a child who's out of school, you have to make sure they're getting reimbursed 2/3, not 100%. Okay. Employer notice, the poster is on the left-hand side. Everybody should be very familiar with this. There is a posting requirement. So the poster needs to be posted as of April 1st. If you do not have it up, I would suggest putting it up as soon as possible. It is a requirement that all employers post this. This gives information regarding the FFCRA's paid leave provision. It gives information on how to file a complaint with the DOL, which has to be made available to employees. It also has frequently asked questions by the Department of Labor. So because there are a lot of people who telework, we've gotten a lot of questions regarding, well, how do I post this? Most of the time you post it in a common area within the building. I would still suggest if you have employees coming to the office, it's posted there. To ensure that your remote workers get this, you should send a mass email to all employees with the poster. If you have intranet, you should send an email there. And if you have any sort of website, company website where you can post this, you should post it there so you can show that you gave the notice to everybody. Make sure that if you have anybody who is not English speaking, let's say they're Spanish speaking, you do also provide a Spanish version of the poster. So the employer notice, the content of the notice, the DOL outlined different employee notice requirements depending on the need for leave. So reason, except school/childcare, the employer may require employees to follow the reasonable notice procedures after the first workday or portion of a workday for which an employee receives paid sick leave. So what this means is that, for example, if somebody has COVID or is sick and is seeking a diagnosis, they should still follow the company's paid sick leave. So they still need to keep in contact with their manager, with the HR department, whoever their contact is, to let them know, hey, I'm not able to work, I'm sick. Hey, I'm not able to work for the next 3 days. Whatever the company's PTO policy is, it still needs to be followed, and the employee still needs to be in communication with that manager or HR representative regarding it. If somebody is not able to work and is falling under the FFCRA for the school closure or for the daycare closure, and they have to care for a son or daughter or a family member, they should ensure that they reach out to the employer as soon as possible, give as much notice as possible. And they still need to follow that notice and advancement and also keeping communication with their employer. So with schools, I have children in school. My kid's school is closed until April 30th. So if I was on leave and not able to work, my responsibility would be to ensure that if school closure continues, let's say they make a new date of May 15th, that they're going to keep the schools closed to. As an employee, it's my responsibility to reach out to my employer to keep them updated. So we just want to make sure that if any employees are falling under the FFCRA leave, they still have to follow policy and procedures of the company to ensure the company and the business is still running like it needs to be.
And you have to make sure that the employees are aware of those policies and procedures. So you can't just implement them now or come up with new policies and procedures now and expect your employees to follow them right away. You have to disseminate the information. You have to talk to them. The Broward County schools, I believe, are closed for the remainder of the year. So you need to talk to your employees, and employees need to talk to their employers, figure out how to continue working, teleworking, maybe coming up with different ways and thinking outside of the box so that you can continue the relationship and continue to be and abide by these rules and new regulations.
So we're going to talk about the documentation. This is to substantiate the leave. Again, this is really important because the leave is protected and there is also a tax credit to it. Not only is it going to be governed by the federal government under the FFCRA, it's also going to be governed by the IRS. So the Department of Labor and the IRS provided details on required documentation. So on the base level for the EFMLEA, tongue twister, and the EPSLA, you have to have the employee's name. You have to have the dates for which the leave is requested. You have to have the qualifying reason for the leave. And there should be oral or written statement that the employee is unable to work or telework because of a qualified reason. In HR, I would always advise that everything be written down. So although somebody might call you on the phone and give you an oral explanation, you should always have them follow up by email with what they're saying so you can have that documentation.
As Kristen just said, everything in writing when possible. You also have to note that the employee must be unable to work, not that they don't want to work or it's harder to work. They have to be unable to work for you to be able to get that credit from the IRS. So make sure you have all of your documentation in order and everything in writing, as Kristen just said.
So if an employee has a healthcare provider advises the employee to self-quarantine, the documentation required for this is the employee must additionally provide the employer with the name of the healthcare provider and what the quarantine is due to. So from what I've seen in practice, CDC has provided this information, physicians have provided this information. This wouldn't be something to where somebody's voluntarily telling you they're self-quarantining. This quarantine would be directed by a healthcare provider. So you should always require a written statement from the healthcare provider to substantiate the leave. So ensure that if an employee is told, oh, my doctor said I need to be on leave for quarantine, they need to have documentation from that healthcare provider. If the employer, not the healthcare provider, instructs the employee to self-quarantine for safety reasons, this would not be eligible. So just keep that in mind. This is only for employees that are under the direction of a healthcare provider. So documentation to care for an individual. An employee must additionally provide the employer with either the name of the government entity that issued the quarantine isolation for this individual, the name of the healthcare provider that issued this quarantine for this individual. With the IRS, individual's name and relationship to the employee has to be documented. You should also require the written statement from the healthcare provider to substantiate whether this reason would qualify. So an example of this is if you have, let's say, your elderly mother living with you, she is diagnosed with COVID, you have to care for her because she is unable to care for herself. You would need that documented by the healthcare provider to provide to your employer, and the employer would need to keep that as documentation. Documentation for the school childcare closure. With this one, the employee needs to provide to the employer the name of the son or daughter being cared for. So if you have 3 kids, you have to document the name of the children you're caring for, the name of the school, place of care, child care provider that's going to be closed, that is closed, or that's unavailable due to COVID. You also have to document that as a representation, there's no other suitable person who will be caring for the son or daughter during that period, which you have to take leave as an employee. So you have to make sure that's documented on there. And then with the IRS guidelines, for a child older than 14 years old during daylight hours, a statement that a special circumstance needs to exist and be provided to the employer for leave. So if you have an employee who has a child 14 or older that they're requesting this leave, you do need that statement so you can have that on documentation for the IRS.
Again, this goes to the fact that the employee has to be unable to work, not that they don't want to work or it's harder to work.
So record keeping requirements, this is really important because again, this documentation is required by the Department of Labor, also by the IRS. So the Department of Labor, the requirement is the employer is required to retain all documentation for 4 years. So you want to retain this regardless of whether the leave was granted or denied. So any leave request that was submitted and whether they were granted or denied needs to be kept for 4 years. So if you're doing any sort of filing, I would have a employee snippet in their file regarding the FFCRA where any documentation can be put in there and you have to keep it for 4 years. If an employee provides an oral statement, they need to provide some sort of written statement, and they also need to provide the support for the paid sick leave, whether it's under the expanded family or the medical leave that you need to have that documentation for. So although employees can request this initially orally over the phone, you do need to have that documentation in writing to be kept on file for the Department of Labor. So record keeping requirements, this is for the tax credits that are going to be under the IRS. So documentation has to show how the employer determined the amount of emergency paid sick leave and the EFMLEA. So you have to make sure that any sort of calculation that you do for the full-time employee paid sick leave, for the part-time, you need to show that calculation and document that somewhere so you can have that backup as why you're paying the employee what you're paying them. You also have to document whether there was available work, telework, or the paid leave that all work together. Documentation to show how the employer determined the amount of qualified health plan expenses, if it was allocated to their wages, if you're doing that. Copies of any IRS Form 7200 and the Forms 941 submitted to the IRS. And then any other documents that are going to be required by the IRS. So you just want to make sure that whatever calculation that you're doing, whatever documents the employee is turning in, they all need to be kept together in a file with the employee for 4 years.
Make sure to document everything as specifically as possible. You will need the information to request the tax credit, and at this time, we have no idea what information is going to be needed. So it's better to have more information than not enough and lose the credit. So documentation is key when it comes to these things in writing.
In the last slide, these are Families First Corona Virus Act resources that are very good resources for you as an employer to look over. The frequently asked questions, I look at literally every day for different employee scenarios I'm going through. So these are things to where if you do have any questions, I highly recommend these websites. These provide a lot of guidance for employers.
Thank you, Kristen. Thank you, Tania, for your presentation. We do have a couple questions, so I want to kind of go over those real quick before I end the webinar. Give me 1 second. Let me take a look at these. Sorry, guys, I'm having an issue here looking at them, but I am almost there. Give me 1 minute. I'm sorry, guys. For some reason, I'm having an issue reviewing the questions. I'm not able to see them, but we did have a couple of them, and I apologize that I'm not able to. I do see one of them, but they're showing up very small. Let me try one more time and see. I'm sorry, I'm gonna put everyone on mute real quick. All right, so I'll try my best. I'm sorry, I don't know what's going on, but I am able to see one of them. So one of the questions is, if an employee is out of one of these COVID reasons, but they can telework, are they allowed to choose not to work and still get paid?
No. If they are able to telework, then they wouldn't qualify under the emergency paid leave or under the expanded FMLA. Also, another big one, I had a different presentation that this question came up. I didn't talk about it. You can only get paid for the leave one time. So if you get COVID and use 2 weeks, and then let's say you have to quarantine again or something, you can't use it again. It's a one-time use item.
Yes,
Thank
and
you.
as stated throughout the presentation, you have to be unable to work. So being able to have different hours or working from home, or maybe if the employer is allowing the employee to, cut the work into pieces, then the employee is not going to be eligible because they are able to work.
Thank you, Kristen and Tanya. I'm not sure if it's a question, but there is a statement here of documentation required will omit HIPAA and indicate condition. I'm not sure what that's related to. There's nothing more to specify that.
If it's with that, it may be a concern if you're violating somebody's HIPAA by getting their COVID testing. This is something that is HIPAA protected, that you do have to have, in the HR file, in the protected file, but you will need that for documentation. So any sort of healthcare provider will need to provide that documentation. It needs to stay protected within the company, so you can't tell anybody that anybody has COVID or has tested positive for COVID, but that documentation is needed in order to satisfy the documentation for the IRS and the Department of Labor.
Thank you, Kristen. I do have another question here. I have an employee that has to take care of her daughter, 6 years old, because school is closed. I am paying her 2/3 of her pay right now. How long is this for? 80 hours.
So it will depend on obviously where she lives when school gets back in session. If school is out the rest of the year, emergency paid leave for child care paying 2/3 is 2 weeks, and the expanded FMLA paying 2/3 is 10. So that would be a total of 12 weeks. But you do have to make sure, depending on where she is, schools might open before the expanded FMLA is exhausted. So whichever would come first. But the maximum time to have off caring for a child out of school or without childcare is 12 weeks.
Thank you. We do have another question. What are the forms that we need to fill out in order to get the credit for the leave?
So there's two sides to this. There isn't an actual Department of Labor request form. Most companies are either putting together a form. I think SHRM has an example of a form that employees can fill out to have that documentation on file. You need to work with your payroll company to submit these leave hours to ensure they're documented in your payroll system correctly. And that's how the payroll credits are going to be calculated on your 941.
And make sure you work with your CPAs as well so that they understand that you are going to be asking for those credits, and they might have other documents that they might want you to have to be able to request those credits.
Thank you, Kristen and Tanya. That was our last question for this webinar. I'd like to take the time to thank our presenters, Tanya and Kristen. Thank you very much for everything that you guys provided to us today. I want to thank everyone that participated. As I mentioned in the beginning, I know there were a few people that came in late. We will be sharing this recording and the presentation with the with our accredited businesses, so please be on the lookout for that. And also be on the lookout for other webinars related to COVID-19. A lot of things are changing, as Kristen mentioned, and we just want to make sure that we, as an organization that's out there for the community and our businesses, get this information out to you guys as soon as possible. So please be on the lookout for that, and everyone stay safe and have a great weekend. Thank you again. Take care.
Thank you. Have a great day.